6:30, the planning commission meeting of August 5th. Comes there. Are there any comments on the minutes?
Roll call.
Oh, yes, we need a roll call. Thank you.
Mr. Propper.
Here.
Mr. Giller. Here. Lees.
Here.
Mr. Smith. Here. Mr. Guerra.
Here.
Ms. Clark.
Here.
Mr. Director.
Here.
Thank you. Okay. Now, any questions or comments on the minutes? Okay, the minutes will be approved. Chris, are there any changes to the agenda?
No changes. No changes this evening. Sorry.
I'm going to open the meeting to public comment on historic preservation issues that are not on the agenda this evening. As part of a certified local government, we are asked to take public comment on historic preservation issues in the community. With that, I will open the meeting to any public comment. Please raise your hand with the icon at the bottom of your screen, or press *9 if you're attending the meeting by phone, and then *6 to unmute yourself. Anybody on, Chris?
There's no hands being raised.
Okay, thank you. Then we can move to Keely, a discussion of ex parte contacts and other matters related to quasi judicial decisions.
There. Okay, there we go. Good evening, everyone. I'm Keely Ambrose. I'm the town attorney for the town of Breckenridge. And tonight I'm going to talk to you a little bit about, I'm going to sort of come at this from a slightly high level and then narrow down, and we're going to talk about the foundational documents for the Planning Commission, and then also get into more details about the legal rules around what you guys do every other Tuesday. So the other thing I want to just start with is that this is, just sort of general. This isn't specific legal advice, so we're not going to talk about any specific cases that are before the Planning Commission, which you'll understand why we won't do that as we get into the discussion. So if you have any general questions about process or things, that's great. If you have specific, we can talk about those in this forum. If you have specific questions about anything particular, then I would ask that you hold those questions and we can talk about them later individually. Is that good? Everybody get it? Okay, great. So to start with, I have it. The foundational documents for the Planning Commission start with the town charter. And I think most of you know this, but the town is a home rule town, which means essentially that it has exclusive jurisdiction over matters that are of purely local concern. That means that it preempts, local rules preempt state law where they conflict, but only for those issues that are of purely local concern. For your purposes, land use is generally considered to be a matter of purely local concern. However, there are some areas where state law has been declared to be a mixed, basically a mixed bag when it comes to whether it's a statewide issue or a matter of local concern. So there are some instances where state law does preempt local law and regulation on certain matters. The municipal charter sets out all of the guiding principles for the town government, including how the form of government that we have, which is called a council manager form, which is essentially the council makes the broad policy decisions and the manager carries them out. But the council also is sort of restrained, I guess, in some ways by the town charter from interfering with some of the manager's decisions. So it's a pretty effective and very common form of town government. The charter also sets out the council makeup and powers, things like elections, municipal court, and then also talks about how commissions are formed. Section 9.3 of the charter talks about the planning commission and sets out the general parameters of having 7 members and the various qualifications of having to be electors within the town jurisdiction. The town code, which will is the second sort of next foundational document down. Title 2, Chapter 2 of the code is specific to the planning commission and talks about, so again, it sort of echoes the charter in terms of 7 members, 4-year terms. Your terms are limited to 3 consecutive terms in office. You can be reappointed for additional terms after the passage of 4 years has gone by between your third term, and then you can wait 4 years and then you can be reappointed again. Vacancies, so you can't miss 3 consecutive regularly scheduled or special meetings, and you can't miss 5 regularly scheduled meetings over the course of a year. So if that happens, you could be removed from the planning commission. You can also be removed for misconduct. We're gonna get into that more later. A quorum is 4 members. And then the powers and duties of the planning commission. It's the municipal planning commissions, boards of zoning adjustment, as now or hereafter set by law, the powers and duties set forth in this chapter, and such other powers and duties as may be established by the council from time to time. So that's sort of the parameters of what you do. And then it also, this section of the code also sets out your compensation and benefits. So the development code, this is the second most important piece of what you guys do. Title 9 is your cookbook. All of the process and the policies that are applicable to every project that you guys review are set out in Title 9. You all know about absolute policies versus relative policies. There is some discretion baked in there, but you have to remember that your decision-making has to be consistent and in general accordance with established rules, regulations, and policies, so as not to be arbitrary and capricious. We will get into that a little bit more as well. Most planning commission decisions are considered quasi-judicial, and this is a really important piece. You are determining a quasi-judicial action is one where you're determining the rights of a property owner vis-a-vis a particular piece of property. It is an individualized assessment of rights as to that property. And because it involves property, it implicates, oh, am I too close? Not close enough. It invokes the Constitution of the United States and the state of Colorado. This is different than a quasi-legislative act. The town council very commonly takes quasi-legislative acts. Those are things like, the legislature takes that where you're creating a broadly applicable law or rule. One of the areas where things get a little confusing, and I know it's come up sometimes, is with development agreements. Under the code and in the way that those agreements are made by town council, those are legislative acts. So essentially what they're doing is creating individualized rules that apply to a particular piece of property. There's potential some debate as to whether those are really quasi-legislative or whether they're quasi-judicial, but the process that they go through before the town council and the way that it's set out in the code makes them quasi-legislative. So they are equal to town code in terms of how you apply them. Does anybody have any questions about that in particular? Okay, so most often you are having a quasi-judicial hearing about a particular land use application. You're acting as the judge or jury for that particular application. There are rules regarding ex parte conflicts and pre-decisional, making decisions prior to the hearing. So like before a judge or jury, right, you have due process that applies to the applicant and also the public. And the principles of due process are really notice, an opportunity to be heard, and then findings based on facts presented in light of the applicable criteria. So for you all, the code is always your applicable criteria, right? There is no other applicable criteria besides the code or potentially the development agreement if that's applicable. You don't get to bring in outside criteria as long as you stick to the code, you're going to be good in terms of that part of the fundamental fairness and the due process that's due to an applicant. The notice piece is generally handled by staff. So that's, the notices that go out before a planning application is heard by you and involves, that's all set out by the code in terms of who gets it and how far in advance that notice gets sent out. And then the opportunity to be heard is really important. And that's important for both the public and for the property owner. The property owner the property owner, I'll try to speak softer. The property owner, if that's any better. Thank you. Sorry. Okay. Oh, that's better. So the property owner is the one who's bringing the application to you and seeking a decision, a determination of their rights as to their property. Their rights, their due process rights in this context mean that they get to come, they get to hear all of your comments, they get to hear the public's comments and any objections, and that they have the opportunity to both hear everything that's being said about their application and also respond to it. The public's right in this context is to come and basically give their opinion, right? They get to come and say, hey, I think you should think about X, Y, Z. And then you as the planning commission, your job is to take all of that information that's all been provided within that public hearing context, in that public hearing process, and then make the decision based on your criteria. It's really important that you don't rely on other information that you received outside of that hearing. And the reason for that is because that's information that the applicant did not have a chance to hear and respond to. So if you have gone on, for example, gone to a site visit or something and talked to people on the site about the project, and then take that information into the public hearing and use it as part of your decision-making process, the applicant doesn't know what was said. They can't respond to it. They have no way of being able to participate in that portion of your decision-making. So that's a violation of their due process rights to do that. So everything that your decision is based on has to be provided in the public hearing venue. Does that make sense to everybody? Anybody have any questions on due process in particular? Okay. So, Rule 106 appeals. So those can happen. That's the main way that any aggrieved member of the public or an applicant, that's the way they can, it's a continuance of the due process right is the 106 appeal. That's how Colorado law provides an avenue for someone who's been aggrieved by a quasi-judicial decision. So that goes directly to district court from either your decision, a staff decision, or council. The standard is an abuse of discretion and whether you've made an arbitrary and capricious decision. The standard, I would say, is pretty high to overturn a quasi-judicial decision under a 106 action. There is essentially, is there any competent evidence in the record to support the decision? And generally the way our meetings are run and the wonderful job that our staff does and the wonderful job that you all do, there's, we're pretty good on whether or not there's enough evidence in the record to support the decision. That could be different if it were a process violation. So if it's noticing was wrong or somebody had ex parte contacts, and go back up. I forgot to clarify that idea of getting information outside of the public hearing, that's called an ex parte contact. So it's essentially like a judge talking to a witness outside of the courtroom. And, we all know that's not okay, right? Or a jury that's after they've had the trial, the jury goes back to deliberate and somehow, some person who has an interest in the outcome of the trial finds a way to give the jury new information. Can't do that, right? Neither can you guys. So if that sort of thing happens, that is an automatic, it's bounced back, for a new hearing. If there's a process violation like that. Yeah,
The ex parte, those restrictions, they apply while an application is active or even after we've made our decision?
they only apply up until the point you've made your decision. Once your decision's made, then it's over, right? Yeah. But I will clarify, because of the way that we have call up process with the council, the council might still call it up, and that prolongs that period where you shouldn't be having, because it could come back to you and it also could go to council. So to be safe, everybody should just zip lips until council's either decided to call it up or not.
So Keely, let me make sure I understand what you said.
Yeah,
The process of the call up by the council,
mhm.
they would actually have to find an error in the procedure or a conflict with.
No. So I haven't actually even
They-
gotten
they
to the
could just-
call up. Yeah, the
they can
council,
reverse the decision just because they want to?
well, the council can call it up for whatever reason they want. If they want to take a second look at it, if they, think there was an error, if they want more information, that's at their discretion. They are still bound by all of the rules that I've laid out for you all in terms of how they have to consider a quasi judicial decision. So they still have to stick to the code.
So their restriction is not as tight as a restriction of an appeal of a.
Correct, yes. No, they're still sitting as the sort of lower quasi judicial body that is referred to by the Rule 106 appeal process. That's in state statute. The town code governs what happens between planning commission and town council and call-ups, and that's a town rule. And because it's on a matter of local concern, we get to sort of do that how we want. Yeah,
Thank you.
yeah,
Again, I'm speaking theoretically
Yeah.
here. So even if if it should be called up and the town council makes a decision, should the ex parte and such could even continue further should the applicant appeal or challenge it in court, correct?
I would say no at that point, because it would technically be a new, if it gets kicked back by the district court after review, it will basically be a new application.
Mhm.
I think, so the rules would start again. Yeah. And I think, in that sort of situation, I guess I'm going to reserve the right to say, if we are in that situation, I'd want to maybe talk to you guys about it, because I think it also, my interpretation of that might change depending on what the appeal is based on. So if it's a process one where I'm like, ooh, we messed up, then I might say, just keep this is gonna get kicked back, so let's keep things clean and don't have any discussions about this with anybody else. So I'll reserve that right, and if there's any one in particular, we can talk about it after.
Okay.
Okay. Okay, so that's you guys are familiar with the call-up procedure, so I don't know if I need to go into a lot of detail, but essentially the council has the discretion to call up any decision of the planning commission and essentially re-review it. And that's their prerogative, and that's a discretionary action that the code gives them. But they are still bound by all of the rules that apply to a quasi judicial proceeding.
I have a question. So we're quasi judicial, and it feels like sometimes we start talking about policies, like today we're going to talk about fire policies and some of the code stuff. And to me, I was kind of surprised that we're asked to give advice on that because we're supposed to be just be judicial. It's almost like we're becoming a little bit legislative.
So you don't have any legislative authority, right? You don't adopt code. That's what town council does. But you also serve as an advisory body to council on land use matters. So they can, ask you to look at anything. And in those situations, you are not acting as a quasi judicial body, right? You're just acting as an advisory, board, commission to give advice to council on matters that they've asked your input for. I mean,
Is that in any of these documents? Do that?
yeah,
Okay,
yeah, they can do that. It's not your primary purpose.
okay.
But there's many less legal issues with that, which is why I don't really have it covered as a thing, because you're just providing input, recommendations.
Okay.
It's certainly part of your purview, though. We've done this many times, talk about materials, whatever it is, bring it to you many times. There's whole commissions like the BOSAC, Open Space Advisory Commission. Pretty much everything they do is just as an advisory role to the town council.
Yeah.
They make recommendations. They don't do any of the
Yeah.
judicial at all.
Yeah, they're really pretty different functions when you think about it. And I mean, I'm here to talk about sort of liability and that sort of thing. That all is, inures to you because of your quasi judicial capacity. You have essentially zero liability related to your advisory, policy recommendations.
Okay. Thanks.
Does that help?
Yeah.
Yeah. And I don't know how else to describe it except to say, I mean, Mark's absolutely right. There are whole commissions that they only give recommendations. You still are bound by the ethics rules, and we're going to get into those. And anything that you do as a commissioner for the town, you are considered a town officer, a town official. So, keep that in mind when you're talking about policies and when you're acting outside of the quasi judicial context. But as a board member, so you still have those obligations. But the real legal issues are around your quasi judicial capacity. Okay. Ethics. The town code does have a pretty substantial ethics section. It is mainly organized around financial conflicts. So you cannot vote on something if you have an ownership interest in a business that's part of the application, an employment relationship or prospective employment relationship, an ownership interest in the real or personal property, a close and continuing business relationship involving a regular purchase of sale of goods or services or property not generally available to the public. The question that you have to ask yourself when you're talking about whether or not you have a conflict of interest on a matter is whether the commission is voting on something that would have a reasonably foreseeable material and beneficial financial effect for you that's distinguishable from its effect on the public generally. So yeah, you are not allowed to vote on those matters where you have a conflict of interest. If you have a question about whether you have a conflict of interest, then you would consult with me and staff, and we'll talk about, whether it is something that you need to disclose. You would disclose the potential conflict prior to the meeting, and then the commission determines if there's a conflict, and if that is so determined, then you have to leave the chambers during the discussion and you can't participate. Anybody have any question about conflicts of interest? Okay. So there's some prohibited conduct in the Code of Ethics regarding the disclosure or the use of confidential information that you might be party to as part of your role with the town. You can't solicit or accept gifts or services or things of value from people for the purpose of influencing or attempting to influence your decisions on any particular matter. You can't perform an official act directly and substantially affecting a business when you, you or a member of your immediate family is an employee of the business, owns 10% or greater, or is a director, officer, partner in the business, and you also cannot affirmatively act to obtain employment or gift for family from a person whom the officer or employee is in a position to reward with official action. So basically it just means you can't use your position to benefit you or your family. Any questions about those? Violations of these rules would be grounds for removal from the commission. Open meetings laws. So these meetings are all open to the public. That means they are required to be posted. If 3 or more of you are in having a discussion about something that is related to the planning commission, that would be considered to be a meeting, and that has to be noticed and open to the public. So don't do that. And if there is action to be taken, the agenda has to be posted 24 hours in advance. Those are just sort of process things related to open meetings. So the activities of the Planning Commission are also subject to the Colorado Open Records Act. That means all emails and writings are subject to disclosure if there were a request. So it's this one's a little hard for you guys because you're not full-time, officials for the town, and you do this as a part-time thing. And so you use I think most of you probably use personal email for correspondence with staff and things like that. That's fine, but just remember that in the event that there is some sort of records request, you would have to go through all of your personal emails and provide the ones that are responsive to their requests that are relevant from your personal email. It's a giant pain. So just keep that in mind. Any questions about the open records?
Personal laptops.
So yeah, you can use your personal laptop. But just, I have not seen this happen, but I think it has the potential to happen where someone's use of a personal laptop becomes, use of a personal laptop in their official capacity means that by some, depending on what the request is for and how integrated the personal stuff is with the official stuff, that you end up having to give your laptop to like a judge so that they can go through it. Like that would not be great. So to the extent that you can keep things even just organized on your laptop separate, that's helpful, right? Any sort of, if you're saving documents and notes and that sort of thing, keep that in a separate file that's very clearly marked and identified so that you can say, this is the file, there isn't anything anywhere else that would be relevant to my official duties as a planning commissioner. Okay, liability. So in general, public officials are covered by the Colorado Governmental Immunity Act. That's the legal protection, and CIRSA, which is our insurance protection. The CGIA protects government officials and staff from liability for acts that they commit in the course of their duties. This is an important distinction. If you do things that are outside the course of your duties, the CGIA does not cover you, and neither does CIRSA. So don't do that. That would mean, examples are if you had an application that was before you and you were out like talking to the public, advocating for or against it, right? That would be outside of the official scope. You are not supposed to do that. And it is very clear that you're not supposed to do that, right? And you would be interfering with someone's rights by doing that. So that's sort of the type of thing. Also, if you were to somehow, I don't know, like if you're driving on your way to planning commission and you get in a car accident or something, that's not within the scope of your duties, right? That's outside.
Yeah, but I assume site visits would be
Mhm.
covered.
Yep, site visits would be covered. But again, I would be careful with site visits. You can go to the site. You should not engage with people on the site because that is not within the scope. You shouldn't be doing that.
That's ex parte.
Yeah, exactly. Yeah.
That's why on site visits, we'll say staff is here to kind of present the information. We're not having any deliberations about this at this point in time. It's just fact finding is all it is.
Yeah. And you can do, so if you go as a commission, something to just clarify, if you're doing a site visit as a commission, that is publicly noticed. So the public can go, the applicant can go, it's sort of part of the meeting history behind the application. When you go by yourself, you know, if staff's there, no one's going to be answering your questions because it's not a publicly noticed meeting, and there's no ability for the applicant to know what you did or did not find out during that visit. Does that make sense? So I would say, you know, the main takeaway from this is just to remember that, you know, what you do here is important, and it involves constitutional rights. And so you have to remember that, and remember that you do have sort of pretty specific duties and responsibilities. And we, you know, are very thankful that you all are here and that you're doing that, because it's really important work. And I am here to help you, as you know, whenever you need it. And so is staff, to help guide you if you feel like you're getting stuck with something. I would say overall, you guys do, I mean, I know because I was a member, you guys do a pretty good job and you know the code, and you're great at sticking to that. And then also, you know, making sure that applicants are abiding by all of that. So that's the last thing is, you know, again, you're on here to serve the community interest, not your individual interest. It's important to build a good relationship with each other and staff, as well as with the greater community. Sorry, respecting the allocation of responsibilities was not really for you. That was part of a different presentation that got left in there. But, you know, having transparency in meetings and communications, it's really important that when you're considering an application, that all of the stuff happens here at the hearing. And then, you know, just sort of your personal approach to this, and what are your standards of conduct that you hold yourself to, because that's important too. That's it.
One more question.
Yeah.
How do these rules apply on town projects? Because technically the applicant, we're just advising them.
Yeah, it's town projects are not quasi judicial. So those things do not apply. They are considered legislative essentially.
Okay.
Yeah.
So the actual ex parte issue is addressed in the Planning Commission Rules of Procedure also. And, you know, it talks about how written, oral, or electronic contact from someone to the commission outside of the actual hearing process, that's essentially what it is. And then it goes on to say, when a person attempts to make that contact, your approach should be to just try to tell them, I can't accept this information now, need to accept it in this forum here, or, you know, in an email or letter to the entire commission. So all of you have that same information as part of the public record. And then it goes on to say, if you have had a ex parte contact, they do happen sometimes they might be difficult to avoid. You must report the information and identify the source and date of contact to the full commission for inclusion of the formal record at the public meeting. So occasionally we've had to do that, and I appreciate folks that have brought that to the attention of the whole commission, just to be upfront about that. And then finally, I just wanted to mention that the ex parte rules do not apply when we're talking about one of you talking to staff, the director, the town attorney, or any member of the ComDev staff. You're welcome at any time to reach out to us to ask questions, clarifying questions, whatever, on applications. So.
Yeah, those are great clarifications. We are essentially your staff. when it comes to planning applications, so we can answer your questions. And there was something I wanted to, I'll think of it, about when you properly disclose an ex parte contact, and for usually, as long as it was limited in scope and, you cut it off early and, did all of the right things, it doesn't ruin the application, right? Because you disclose it and you make all the information available to all of the planning commission, so everybody has it, and so does the applicant and the public. That's how you cure that. It's when you don't disclose it that it becomes a problem, or if it was an ongoing thing that was happening that that makes it much harder for everybody to be a part of it, right? If you've been having numerous offline conversations with someone about a project, those are really hard to capture and then cure by giving the content of that conversation to everybody, because it just doesn't work that way, right? You can't remember what was all said in a conversation and not, there's no recording of it. That's a much harder thing to cure. An inadvertent email that gets sent, or not inadvertent, sometimes they're intentional, an email that gets sent to you, that's easy, right? You can say here, or somebody who tried to start a conversation and you said, I can't, come to the meeting and talk about it, or send an email. Those are easier.
What is the process if you were to have an inadvertent contact? Like, do you just fill out a form, contact staff first, or just bring it up at the next meeting?
Best to contact staff first, just so
Okay.
that we're aware of it, so that we can then, when we start the meeting, then you would just, we'll help you prepare how to disclose it.
Okay.
And then you would disclose it at the meeting.
Okay.
Yeah.
I had an example one time where the project we were reviewing was across the street from my house, and so Peter had me disclose that.
Yeah. Yeah, and that's there is also something called, I didn't really directly address it here because it's not covered in the ethics code, but there is something called the appearance of impropriety. And that is something oftentimes we will ask you to disclose something when it looks like it might be a conflict, even if it isn't actually one. So we might say, we want you to come and disclose this so that everyone is aware. And then the commission, usually what happens in that situation is myself or Mark or someone will then ask, well, do you feel capable of, since it's not actually a conflict under the rules, but it has that appearance to it, we'll say, are you still going to be able to listen to this application and make a decision on it in an impartial manner? And if the answer is yes, then you can continue. If for some reason that, appearance of impropriety actually is a conflict for you personally, because that can happen too. Somebody might actually have such a strong feeling about something that it becomes a conflict, and they can't answer that question. They can't say that, yes, I can review this and make a decision impartially, and then they would have to recuse themselves. So that's just that sort of conversation that we go through to make sure that, even if it's not technically a conflict under the rules, it doesn't become one.
Thank you.
Yeah.
Are there any further questions for Keely?
Very helpful.
Great. Thank you very much.
You're very welcome. Good to see all of you.
Okay, the next item on the agenda is the DeFreeze Home Child Care Business Class B Minor Combined Hearing, PL 2025-0201. Cliff?
Thank you, Keely. Alrighty, thank you, Susan. So this evening I have a Class B minor application for combined hearing for the DeFreeze Child Care Facility or business. Typically, we are reviewing in-home businesses under Policy 38. For this one, since it's an in-home childcare facility, it's going to be reviewed under the subjects of Policy 38.5. So ultimately, there are some very specific kind of review criteria that the applicant has provided. Ms. DeFreeze is not with us this evening, but we'll be able to manage everything more or less, the town requires obviously getting state licensing as well as meeting our criteria as well as the state. For this facility, the state has actually put more stringent requirements, or the ability to accept less kids just due to the size of the townhouse, as well as the adjacent park. So typically within the town, we would allow 12. This specific facility would be allowed 6, with some more flexibility for certain after-school care, or even infant care. All of the specific requirements have been met by this DeFreeze. Luckily, there is the River Park, and I can show up here the location. Perfect. So 91 McGee Lane, just around the corner is the River Park. So the state has allowed her, or basically waived the requirement for outdoor space, to use the public community park. When it comes to parking, the town code doesn't require any additional parking for this use. And then as you can kind of see on this site plan, there's quite a bit of parallel parking, as well as additional parking within the neighborhood that can help facilitate the pickup and drop off of kids for the facility. Staff doesn't have any concerns. We have added a condition of approval just for one of our building officials to go and check out the property just to make sure it meets building code. So once this application is approved, we'll ensure one of our inspectors go and inspect the property. But other than that, staff recommends approval of the application, and I'm happy to take any questions.
Alan, do you have any questions for
No
staff?
questions? Thanks.
Elaine?
No questions.
Matt?
I have just one question about operating businesses in general within like a deed restricted scenario, or
Yeah.
I'm assuming this is like part of the Blue 52 deed restriction
Yes.
sort of zone.
So
Is
the-
there anything that might be in the language of any sort of HOA or in the deed restriction documents that prohibit any business?
Not that I'm aware of. I mean, typically within the town, we do allow in-home occupations, and this would kind of fall in it with just some additional childcare. In the terms of like the deed restriction, that makes no difference for the actual operation of the business. We do waive all the fees for deed restricted properties, just as a cool information.
Okay, thanks.
Do you have any questions for staff?
No questions, thanks.
Mark? Any question?
Just tagging on to Mr. Smith's questions. You just said in-home occupation. To me, there's a difference between in-home occupation and in-home business. And specifically, does the town have a definition for what a business is? Because in a lot of municipalities, there are measurements such as the number of patrons or visitors to the home that would be there to conduct business. There might be a monetary threshold that triggers a certain level of business versus non-business, and perhaps makes that a distinction to home occupation. Can you give us a little bit of clarity there about how the town looks at this?
Yeah. So I, just off the top of my head, I'm not aware of the definition and any specifics, but I'm happy to look in the code and we can talk offline tomorrow. In terms of our policy 38, there's basically a set criteria that the property owner has to meet. And it's discussing number of visitors, storage of materials or stock or anything like that, minimizing disruptions to the neighborhood. As I discussed, the parking requirement for this. So there's a lot of kind of things that you touched on that the town is looking at. So for example, if a property owner wanted to run a construction company out of their home, which is very typical. A person will have an office more or less as their primary address. They are not allowed to store any of those materials on site. We wouldn't want any disruption to the visual aesthetics of the neighborhood or just, the sightliness in the streets and impacts in circulation and et cetera. So town is really, honing in on that information. For this specifically, that's why there was a separate policy created for the in-home business or childcare business. It's still looking at the same parameters around parking, number of attendees. Like for this one, there's only 6 children allowed. So you're looking at 6 drop-offs in the morning and 6 drop-offs in the evening. There's more people in the neighborhood for fly fishing on the river. So it is kind of a ebb and flow, but the town is definitely looking at those parameters.
Just to clarify my question, for example, you brought up the construction company. Another one might be someone who is a psychiatrist or a therapist who would see people in their home. Another might be someone who is occupied reviewing books and never has anybody there, never has any indication of any business going on, but there is some commercial value there. So my question is really how is that distinction made? And so we have an understanding.
So, I mean, ultimately, it would be any commercial activity. And some of the examples that you provided for therapy offices, chiropractic, any at-home office are very, common examples that we see and approve. So we're definitely, aware, I guess, of all of those. I'm a little unsure of exactly, I guess, the direct threshold that the town is like looking at. I would assume it would just be any commercial activity. I would have to once again look at that definition within the development code to see what it actually defines it as.
Another indication might be someone who goes out of the home and walks dogs for people in the neighborhood, never really uses their home, but there could be a sense of commercial activity there.
Yes, sir.
So there's a big distinction between these various things. So
yeah.
So Mark, I didn't find a definition of business when I was looking in here. I mean, we can go to a standard dictionary to find that. But what we do define for just home occupations in general is that they can't, the space that's used like for an office or whatever can't occupy more than 25% of the total square footage of the facility. So that's one limitation that we do have in the code.
but you understand the distinction I'm seeing between home occupation and a business.
Well, it can be the same. And
Yeah, basically like using like a single family neighborhood where the only thing it can be, only type of land use that's permitted is a single family home. If it's basically a business that is not covered under the home occupation section, doesn't meet that threshold under policy 38, then it would not be permitted. Basically, it would exclude anything else. So there's a lot like as you're saying, there's a lot of different permeations of business, but if it doesn't qualify as a home occupation and it's a residential a residential land or a residential property that its only use can be used as residential, if it doesn't meet the qualifications of home occupation, then it would not be an allowed use under our code.
You could argue, I think, successfully that someone that has a job, works from home with a computer, is occupying the house and has a home occupation. So I think that the distinction there is kind of.
Are you saying relative to a deed restriction? Is that?
No, just relative to any residence, whether it's deed restricted or it's not deed restricted in Breckenridge.
Yeah, I guess I'm not.
I guess
I don't exactly.
Wants to regulate businesses that are operated from homes, whether they're deed restricted or whether they're not.
Yeah, beyond our land.
Big house in the Highlands, or it's a house in Wellington. I think that the town wants to have some say about what kind of business is going to be run or not going to be run there.
Yeah, if
And
you're,
I'm saying that I'm having a hard time understanding the distinction. I clearly understand the distinction between a
Mhm.
construction company and somebody that's, let's say, grooming dogs in their garage.
yeah, I mean, beyond land use regulations, anyone that is, I guess, conducting any type of business within the town has to get a town business license through the finance department. So the town does have a very strong interest in anyone conducting business in the town, and that in to the threshold that they actually require that, even if you were, I'll use the example of a bike company that's coming here for Bike Week or for the Firecracker, it wants to do demos where there's no exchange of money, they still have to get a business license to operate within the town limits.
Yeah, my gray area is about home occupation and something less smaller than that. But anyway, let's move on.
Yeah, I guess like what I'd suggest as a final thing is maybe read through policy 38 and then if you know, if you have questions beyond that, we'll be happy to talk offline.
Thank you.
Thank you, Mark. Mike, any questions for staff?
No.
I had one question, Cliff. Excuse me. I noticed in the discussion that Ms. DeFries has received a provisional 6-month license. Does that mean that this is going to come back to the planning commission, or will staff handle it after that?
No, so kind of for this particular one, Ms. DeFries has actually been in operation for many years now. And the state has actually come back asking for a zoning letter from the town, but she never actually received approval. So while we are kind of working through everything, she has a probationary license right now. And once we get this approved through town council and she agrees to the development permit, she will then be given her full state license.
I see.
Yes, ma'am.
At this point, I'm going to open this to public hearing. If you are online, please raise your hand with the icon at the bottom of your screen, or press *9 if you are attending the meeting by phone, and *6 to unmute yourself. I don't see anybody in the audience. Is there anybody online?
No one is raising their hands online.
Okay, thank you. Then I'll close the public hearing. Now we'll go to planning commissioner comments. Ellen, do you have any comments?
Comments?
No comments.
Seems to meet policy 38.5.
Okay, Mark. Ethan, any comments?
No comments. Thank you, Susan.
I have no comments.
Madam Chair, I move that the Planning Commission approve the DeFries Home Child Care Business PL 2025-0201, located at 91 McGee Lane, with a passing score of 0 points and the attached findings and conditions.
Thank you. Chris, you want to?
A second.
Oh, thank you.
All right, Ms. Gort,
Approve.
it's proper.
Yes.
Mr. Smith,
Yes.
Mr. Guerra,
Yes.
Mr. Lees,
Yes.
Mr. Fruchter,
Yes.
Mr. Giller.
Yes.
Okay. Then I think we can move to the work session on structure hardening and site requirements work session. Thank you, Keely.
Thanks, Keely.
Cliff?
Awesome. Thank you, Susan. All right. I don't think Ethan will get in our way, but I'll leave him up there in the corner just so you can still see him. So this evening, we're going to open up a discussion on a work session regarding structure hardening and site and area requirements. So as you may know, wildfire is a huge concern in the state of Colorado and, all of the West. Definitely after what we saw at the Marshall Fire, as well as in California and Hawaii and such, the state was very concerned. So ultimately, today we're basically going to be talking about the Senate bill that created the code board and then the final adopted code board, and then what steps the town may take in the future. So I know it's a lot of information, and I included the presentation in the packet just so y'all could go ahead and review it. But what we'll do is go ahead and start, just try to get through the slides, and then we can really dive into staff recommendation, any questions and further discussion. So, as mentioned, Senate bill basically created the Colorado Wildfire Resiliency Code Board. This was in 2023. They've basically been meeting for the past 2 years in many different, individual board meetings, as well as smaller kind of steering committees for specific industries and other areas around structure hardening. Staff has been able to listen in to a lot of the conversations, as well as even provide public comment when drafts were out. Primarily, this board is basically looking to, provide regulations to mitigate fire within the WUHI. The WUHI is the Wildland Urban Interface, and it will be a common kind of thread through all of this. The regulations themselves, I guess I can, are specific for governing bodies within the Wildland Urban Interface. So any jurisdiction that has properties within those identified areas, which we'll jump into in a second, should adopt a similar provision or this code exactly. Based on a more recent Senate bill from this year, has extended that deadline to April 2026 for us to adopt a similar code. Looking at the actual code itself, we're going to be looking at the first 5 chapters. There's a few appendices at the end that I didn't include into this presentation. But the first one is really going to be the applicability and the scope of this. So from the jump, this is going to be any new structure within the Wildland Urban Interface. There is additional kind of, I guess, qualifying additions or projects or something like that. So any addition that took the square footage 500 square feet or more would be subject to this. And in addition, 25% of any wall plane or roof plane that is disturbed will be required to come into compliance with these provisions. Luckily, the state definitely listened to a lot of the communities that provided feedback regarding historic structures, and they have added an exemption to this regarding historic structures. There's a few additional criteria that have to be met, but the town specifically would be allowed to utilize this for our historic structures that are within our historic district, since they are already contributing to our National Registered District. For this, basically, it allows the local jurisdiction to create this carve out, but still meet the intent of trying to provide some defensible space and structure hardening.
So Cliff, would those be added to the code that's
Um,
here as an addendum to?
Yeah, no, Mark, that's a great question. And we can definitely get into it in discussion. There's 2 options. We could just adopt this, what we have in front of us, or we can adopt a very similar code. That code does have to be approved by the state before we can adopt it, just for them to basically ensure that it meets the minimum standards of their code. So we could be more restrictive if we wanted to. Yeah,
Not less.
not less. Correct, Mark. Great question.
Thank you.
So Moving on kind of into definitions, I wanted to kind of identify a few of these just to kind of help with our discussion this evening. So some of you may be very familiar with defensible space, but it's basically just creating an area that helps mitigate the spread of fire. That would include kind of thinning of trees, removal of combustible material. There's a lot of parameters. For this definition is slightly different than what we have in our development code, but the overall intent is still the same. Getting into fire intensity classification, this is something specific to the resiliency code. We will get into it to a next slide, but it basically classifies each area within Colorado for what their intensity is, and then what regulations are applied to certain structures. Resistance rated construction. We're probably going to get into a lot this evening, just looking at separate materials, of whether they're fire retardant treated wood or fire resistant materials to begin with. Moving on to the next one. Like I just mentioned, fire retardant treated wood, ignition resistant building materials, as well as non-combustible. So we'll kind of get into that a little bit more in a second, but it more or less discusses all of the different, ignition resistant tests or just the natural resistance to fire. The last one kind of goes back into the defensible space. So ignition resistant planting materials or vegetation. So most common is aspen is a ignition resistant planting. Other is just habitable and occupiable space. Jumping into the intensity classification that we just looked at. This is kind of a map over here on the right, and I'll move Ethan over here. As you can see, this mostly outlines all of Breckenridge. The colors are a little bit different on the screen, just with them blown up with the projector. But it basically looks at the intensity of fire from many different parameters that the state has mapped out for us. The map itself has been adopted with this resiliency code, and it has been updated with more fire science, additional, topography, and the consideration of what the actual terrain and then the density of the town is. Yes,
On
Mike.
that map, what is the core of town that's blue?
Yes. So great question, Mike. The blue itself actually has no designation. The blue that is showing up is actually the property lines that are kind of all close together. Looking as we kind of go out from the center of town, we have a yellow color. On the map, this is more of an orange color. The low intensity classification is yellow. Moderate is orange, and then our high intensity is the red. So you can kind of see a majority of town is within that moderate intensity, but there are a few sections within town that are going to be in that high intensity area that we'll definitely need to consider. Looking at kind of the scale of intensity, there's two different classifications, class 1 and class 2, that we'll discuss within this resiliency code. Class 1 is going to be any areas that have been identified with the low intensity. They're only subject to class 1 requirements within this code. The town has very minimal within that low intensity. There's a few carve outs in certain areas of town, but almost a majority is going to be in that moderate or high, which would fall into the class 2 classification.
That's different than class 1 construction type or class 2 construction type.
Correct. Yes, sir.
Not to be confusing.
Yeah, not to confuse with the typical codes that our building department already utilize. This would be a completely separate classification based on this map of how the fire intensity labels the area. So as I mentioned, it basically identifies certain areas of town to be in class 1 or class 2. So we'll kind of review the structure hardening. It's going to be structure hardening is kind of blanket for both class 1 and class 2. Class 1 then has a few requirements, and then class 2 has a few additional requirements. So it kind of thinks as the higher fire intense, the more regulations you need to do just to harden the structure and mitigate fire spreading. Going into building materials, so applicable to both class 1 and class 2, it's requiring both non-combustible materials, fire retardant treated wood, or ignition resistant building materials. This, like I mentioned, would be for all new buildings, additions of 500 square feet or more, or repairs to any planes of walls or roof structure that exceed 25% of the surface area. As you can see, it really focuses on the resistance of the material, and that's why it's kind of applicable to both of the classes. Once we kind of break down and look at the actual definitions of each of these three, some of them more or less overlap. Like something that is fire retardant treated wood is an ignition resistant material. It would basically meet the tests in the building code to have X amount of fire rating. Very similar to fire retard or other ignition resistant materials, thinking of fiber cement or other composite materials, they'll also meet kind of that fire rating. Examples of each were kind of at the bottom. So non-combustible, always think of concrete, glass, steel, other masonry items. Fire retardant would be any pressure treated wood that's been impregnated with the chemicals to kind of make it fire retardant. And then ignition resistant materials, there's a plethora. If it's wood, stucco, gypsum board, stone, fiber cement, and other composite materials. As we get into class 1, this is the, I would say, kind of bare minimum and the low intensity classified areas. And that's why it's really only looking at the roofing, gutters, and then the ventilation of the building. Typically, these parameters are already nestled within our building code. So we're already somewhat covering these bases. For example, probably 2 years ago, we actually removed the ability to do wood shake shingles within our jurisdiction, and now all roof assemblies must be Class A. So we're kind of already meeting that within our code. For some of the ventilation openings, I'm a little unsure with the building department. We've had some preliminary conversations, but haven't dove into the code too much for the specifics.
Cliff, does someone need to get a building permit to replace their roof? And if they had a wood shingled roof, that's where you would make them do Class A to replace?
Correct.
Is that how it works?
Yes, sir. So any re-roof within town does require a building permit, as well as a development permit. And we would be reviewing the materials for planning, and then building would definitely be looking at that Class A assembly. Yes, sir.
Thank you.
Great question. So as we move on to class 2, that's when it really dives into more restrictive things. With having a higher intensity classification, the state definitely wants to see more structure hardening measures around the structure. So looking at the eaves, under deck areas, the decking material themselves, even the exterior walls, the coverings, other ornamentation or trim, even looking at overhangs, your glazing, door ratings, like it encompasses a lot. For planning, very similar to class 1, we'll be looking at a few of these, but primarily this will be within our building code. And we'll definitely, rely on our building officials to kind of guide and work with us in those further future conversations. As we go into the next site and area requirements, you can basically think of this as defensible space. The town already has a pretty fleshed out policy 22, which is the required wildfire mitigation, and then policy 48, which is our voluntary wildfire mitigation or voluntary defensible space, technically.
But before you go
Yes, sir.
beyond the class 1 and class 2,
Yes, sir.
are there specific areas within the town where the residences are class 1 or class 2, or are they all mixed in together around town?
So we'll all be mixed in around town. So it's based on that map that I previously showed that I identified low, medium, and high. So medium, high are going to be your class 2. Specifically for the code or for the state's recommended code, it would identify different regulations for different areas of town. And we'll get into staff's recommendation later, but we would not be recommending that. We would recommend a
What I'm hearing you
blanket
say is
statement.
Most of Breckenridge is class 2.
Yes, majority of Breckenridge is already identified as class 2, but then you do have to think of our downtown district that is not identified at all. So that's technically not required to be compliant with these provisions. But yes, great question. We'll get into it, but the town would basically blanket statement. All of town would be applicable to class 2, the higher restrictive structure hardening and site and area requirements. So looking at class 1, it primarily focuses on the 0 to 5 foot, that immediate zone. As we've seen in a lot of fires here recently, as well as the discussions that we've had with the red, white, and blue, the first 5 feet is the most important part of the defensible space. It's kind of your last stand. Thinking of embers getting caught in roof eaves or on decks, or at the corner of your house, kind of in some leaves. This is where they really want everything done. So it matches our current code or defensible space within 22 and 48. No combustible material at all. Remove everything. Our code would allow some flexibility, as well as this code, for ignition resistant materials. So thinking of our aspen trees and a few other water heavy vegetation that could still be planted near the home within that 0 to 5 feet, but primarily removing everything. In terms of the actual location of plantings and spacings and such, it basically matches what our code, or I should say our code matches what the state's recommendation is for spacing and trimming up the trees from removing the ladder fuels. The next area that it discusses is site signage, which is a little unique. But staff is really focusing on the address marker regulations that it specifies. In some areas of town, like the Highlands, for example, like this is a great example. Specifically, if an emergency event happened, or not even fire related, if there was an emergency event, being able to identify the driveway that will take you to the house that you need to be at is kind of the intent of this. The last portion for class 1 is retaining walls and fencing. Typically within the town of Breckenridge, we're not seeing combustible retaining walls. They're typically shotcrete or kind of more rock material across town. So we're not really seeing too much of the retaining walls, so staff isn't concerned about that. But fencing is definitely something. So this specific regulation would require non-combustible within the first 8 feet of any structure that a fence is adjacent to.
Well, it says that vinyl is allowed. What's with vinyl fencing? Does it not burn or? Okay.
The code itself does allow for vinyl fencing, but I think it's an exception specific to certain materials. I think it's like if you have done the work to harden the actual structure, you can use vinyl material because it will still melt and be somewhat flammable, but it's not gonna, ignite like a cedar fence. So there is a small clarification there, but I'll need to look back because I think it's
That's
the exterior materials has to be non-combustible for that exception. Yep. So yes, fencing I feel like is a definitely consideration just with our high alpine environment, we don't typically want a lot of fencing, but thinking in some of our neighborhoods, Wellington, Lincoln Park, even Runway in the future has fence standards. So kind of just thinking of those. Next, we're going to get into the more restrictive class 2. It's not much more than what's already required within the town's policy 22 and policy 48. So looking at that intermediate zone, so the 5 to 30 foot, really looking at what plantings, the spacings between them, removing all dead, disease, and other combustible materials that we don't want to see, like firewood, for example, we want to stack that more than 30 feet away from the residence. And then looking at kind of pruning up and tree spacing between the crowns. All of that's basically exactly the same for 5 to 30, as well as the 30 to 100. Our code breaks this down in 2 separate extended zones instead of this expanded zone that the state is looking at. So I'm sorry that was a lot of information, but definitely will help our discussion this evening. So finally, for staff, we kind of just wanted to identify the major considerations for you to work through. Really thinking of our policy 5R. Previously, we looked at those materials with Sarah doing a great job a couple of years ago, looking at what kind of materials we would want to consider versus natural materials that we typically allow currently, identifying any possible points through these provisions specifically, which was a request from town council recently, and then consideration of our structures in the historic district versus outside the historic district. And then the final one is just the fencing standards that we've kind of already discussed about. So keeping those in mind, I'll go over staff's recommendations. The first one is going to be the creation of 2 new policies. So the first one would be the more or less adoption of the Colorado Wildfire Resiliency Code. The second one would basically be creating a second relative policy to award positive points under, and that would require applicants to go to the highest threshold of fire resistance or non-combustible materials to receive positive points. So that's definitely something that staff is wanting to, further discuss. The next one is really just doing a complete overhaul to our policy 5R, reopening that discussion and looking at specific materials that would help with the intent of this code either being fire resistant or non-combustible themselves. The next one are going to be kind of just the catch-all, the rest. So obviously updating our definitions to kind of match or add some of the definitions from this code. Looking at definitely ensuring we have our historic preservation carve out, amending our fence policy or really our guidance on that fence policy, and then looking at any other positive point within the development code. So that's kind of all of staff's recommendations. We do have some questions for the commission this evening, but at this time, I am more than happy to open up the floor for any discussions, questions, or anything. I would like to apologize again. There's a lot of information, but it's a super important cause for wildfires.
Alan, do you have any questions for staff?
Yeah, let's see. How about, I didn't see anything in here about sprinklers as an option for hardening.
Yeah.
I know if you go into Orem,
Yeah.
they have sprinklers over every window, and I asked about them, and they're very visible, and they tried to make them look attractive, but they said that's because if there's a fire in an adjacent building, it keeps it from coming into that one. Anyway, if people put roof sprinklers on or external sprinklers, is there any thought about adding that to the hardening ability to harden your structure?
So I guess to answer kind of the first part, There are discussions with all local jurisdictions and our community partners, specifically Summit Fire and EMS. They are looking at our IFC, the International Fire Code, and it would require sprinklers at a certain square footage of the home. So that
And
kind of
that
lowers-
already exists. Yeah.
Exactly.
Yeah.
They're lowering that.
Okay.
I think right now it's 6,600. They're looking in like the 3,000 to 4,000. So a lot more homes will have those sprinkler systems. 3,000 to 4,000 square feet as a requirement. Colorado's code itself does not include any sprinklers. I am not familiar if that was, discussed within the drafting of this code.
Okay.
But that is definitely a possibility for positive points for, new homes that aren't required from building code to have sprinklers, to add them both for wildfires, but also structure to structure fires.
Now, and I think the difficulty up here in this alpine environment is the freezing.
Yeah, yeah.
And that would probably preclude any exterior sprinklers.
That would only be 8 months of the year. But, the rest of it I have is comment, so.
And having said that, we probably have more of a problem in the summer months than we do in the winter months. But I think that's part of the issue there with sprinklers.
So the rest I have are comment, so I guess we'll see.
Okay. Yeah. Okay, Elaine, do you have any questions?
No, I guess my main question is what you want from us.
Okay.
Guess ultimately it's a
Good question.
work session, so the floor is open. We can discuss whatever. You can answer questions, you can ask staff, provide more ideas, any discussion around the recommendations that we have. It's kind of just a open mic for us to discuss everything.
I don't have anything specific right now.
Do you have any questions?
Has there been any analysis given on how it might affect overall building costs?
No.
And also,
But increase it.
Definitely not gonna go.
does it appear to have many conflicts with our current development code that would have to be addressed? I know there's definitely some exterior material selection that needs to be thought about or revised, but other than that, is there a lot of other conflicts? And if they get missed in the initial go round after this is adopted, what takes precedence, the state one or the current development
Yeah,
code?
no, that's
For
a
decision making.
great question. In regards to conflicts with our development code, I think the primary one that staff is concerned about, and concerned loosely, is the historic properties and anything within the district. So currently on things that are not historic, we are a lot more flexible with what materials we would allow. And then as kind of one of staff's recommendation is reopening that discussion to see if we want to be a little bit more flexible for contributing buildings and other historic properties, and how do we navigate that to preserve the historic character as well as the historic materials, but then meet the intent of both the wildfire resiliency code, but even as Alan has brought up, structure to structure fire is also a concern with the very tight downtown core. In terms of, you kind of mentioned it, policy 5R is probably the biggest confliction right now. We award negative points for materials that are non-combustible or fire resistant, ignition resistant, sorry.
That's
All over the place. Yeah, so there's a lot of specific requirements within our policy 5R to either get negative points or use a natural material for trimming or wainscoting or something. I think those are probably the two main concerns around the code as it is. In terms of I guess which takes precedent, that's definitely something that staff would need to look into. I think it also kind of points back to Mark's question earlier of, do we just go ahead and adopt it, just how it's written, take it, or do we want to go through the process of creating a code specific to Breckenridge because we're such a unique community and we have very specific goals around our historic district and preserving our character. So I think those are kind of the primary aspects.
I think the further on Cliff's comments too, I think one of the things we're actually fairly satisfied at the state level is how they are addressing historic properties. That was one of Cliff prepared, like a nice letter of our initial concerns. And I think our concerns were echoed with a lot of the communities that had historic districts such as Telluride and Crested Butte and Aspen. And I think the state listened to us because specifically where there is it's a historic structure, there is a carve out to maintain historic fabric. But in terms of how well our code works in the historic district as written, the historic district actually kind of worked better with non-combustible materials earlier than actually areas outside the conservation district. We've allowed hardy board and other similar materials on new construction in the conservation district for over 20 years now. We were earlier to allow that because most of our primary buildings in the district were painted lap siding. So it was easier to mimic than using, we were a little bit more suspicious of using those materials to mimic more rough sawn or stained materials that you find typically outside the historic and conservation districts. So I think it actually, it works pretty well with our handbook of design standards. I think, as Cliff said, I think we do need to maybe seriously consider having a little bit more flexibility for materials outside the conservation district, with understanding the added benefit of better building hardening. I think there's should be some consideration for that trade-off, as we've seen, certain materials used now for longer periods of time that, it's not to say that everything that would qualify as a high fire rated product would not receive negative points. But I think that as written now, we could have a little bit more flexibility. Otherwise, we're just to be trading off positive points to offset the negative points for the materials we're asking people to use. And so that's probably the one, those are the additional comments from what Cliff just stated.
Is there a hardy board at a level of non-combustible, or is that considered fiber cement?
Well, hardy board is yeah, it's a brand name. It's kind of like what Kleenex is, the tissue.
Yeah, so
if you will.
it's considered flammable though, still. It's just it's not considered, it's not in the non-combustible category that he showed up there, like metal and brick and stone.
I think per definition, it doesn't meet non-combustible, but it is a super high rated fire resistant material.
Okay.
Ethan, do you have any questions for staff?
I just have a quick clarification. Cliff, you were talking about Class A roofs and cedar shakes, and you said that the town has outlawed or disallowed cedar shakes, but then you also said they have to be Class A roof. Does the code specifically disallow cedar shake roofs? Because you can have a cedar shake roof that is Class A. So the question is it a disallowing cedar shakes, or is it just saying it must be Class A?
Yes, sir. So we outlawed cedar shake itself.
That's what I thought.
And
Okay.
then it requires Class A assembly. I think during the discussions with that, the maintenance with those roofs were kind of against sustainability measures and such like that. So they just outlawed wood shake in general.
So the code says outlawed of wood shake specifically.
Yes,
That's
correct.
what I thought it did. I just want to clarify. That was all I had. Thanks.
Ethan, just to a little more on that. You're right. Before we outlawed them, they could have come in under the Class A if they were treated. And the county had that provision. They may still have it even in terms of how they enforce their building code. The problem is you have to come in and retreat that every few years. And following up on that is an enforcement. And there's no way we're going to be able to do that. So that was part of the rationale for moving to that, along with just insurance companies were getting really nervous about cedar shake roofs.
Yeah, thanks. Thanks, Mark.
Mike, do you have questions?
Ton of comments, not a lot of questions.
Okay.
Since this is a work session, I don't know whether to wait or start.
I think we're waiting because I
Okay,
think.
let's do so.
Actually, I was to add one more comment. Yesterday, I was talking to Lindsay Fluelling, who, is our CLG representative, because we're going through, as a follow-up to the meeting, kind of our final certification for the next 4 years for being a locally certified community. And we kind of got on this topic of conversation, but she's pretty aware of like what's being proposed at the state level. And we talked about how our handbook relates to that. And it seemed like she had a general level of comfort of where the state is and then specifically how it relates to our code. But I think she's planning to offer some trainings in the future, and probably an online training of historic preservation and building hardening, trying to merge these two state goals together. So I think that's something that's to happen in the coming months. And we'll probably, once we learn, the time, we'll encourage any of the commissioners to attend that training.
Okay, thank you. Mark, do you have any other questions?
I do. I printed out the Colorado code and went through it, and I've got some questions specific to that. Is this an appropriate time to address those?
Yes, sir.
Okay. Under Class 2 structural hardening, specifically under protection of eaves and soffits, they refer to using a non-combustible material or by materials approved for not less than 1 hour fire-resistant construction. Now, as I understand that, as we apply it to eaves and soffits, what that would require is the carpenter to put up 5/8 fire code drywall and then apply the wood material, which is usually 3/4 of an inch, perhaps it's tongue and groove, on top of that drywall. Is that what we're thinking about here? Because the other way of doing that would be to use 5/8 or 3/4 inch fireproof
Material.
plywood.
Yes, sir.
And each of these materials has specific hydroscopic problems in the exterior environment, which might necessitate some additional problems after the fact. So just kind of want to understand what we are going to ask a contractor to do and how that may or may not compromise other things other than the fire resistivity of the building.
Yeah. And Mark, I think that's a great comment. So I think for some of those that are really getting almost into a technical building type application, we may have to do is basically take down your question, maybe review it with our building staff, because what you're saying makes sense. But I think also like probably our area of expertise in terms of materiality and stuff in terms of
Well,
code.
I think the point I'm trying to make here is that the way this code is written, there's a lot of ambiguity. And whenever you don't tighten up a code, you create problems for the people that need to enforce it, and you create problems for the people who need to do the work. And that opening creates a tremendous opportunity for litigation. So the more we tighten up this code, if we're going to adopt it, and perhaps expand on some of the definitions so that anybody reading it knows exactly what it means, because what you're telling me right now is that these questions that I have are too technical to delve into.
I think it's like a lot of these will live in more in the building code versus in the development code. There'll be certain things where they live in one document or the other, but I think when we're talking about assemblies and things like that, that will live in the building code. Looks like Mike had a.
Yeah, I was gonna
follow-up
say
to that.
essentially the same thing. There's prescriptive and performance. And this is more performance in the development code, and it gets more prescriptive or more specific as you get into the building codes. But to Mark's point, I think a work session or two, not unlike what Rick Fowd is doing, his really good work with energy codes, could really help bring the local designers and builders and homeowners up to speed.
You know, they have the same thing about fascias. So you're gonna put the fascia on the edge of the rafter tails of a roof. And does that require that you put this sublayer of 5/8 fire code drywall below that? And I think those are important things. As we go down, under exterior walls, I was, relieved to see that they have, said that anything that is heavy timber or log construction, which is a lot of what we see in Breckenridge architectural styles, is okay to use. And wood siding that is a nominal 2 inches in thickness is okay to use. What I'm a little confused about under exceptions, it says exterior wall embellishments and architectural trim, not to exceed 5% of the square footage of the exterior wall. But in the middle of that sentence, it has exclusive of trim on exterior windows and doors. So does that mean that exterior windows and door trims are not available under the exception?
Correct. They must be subject to the fire resistance.
Okay. What if the trim is in excess of 2 inches by 2 inches, which you're allowing on the siding? So if you're allowing 2-inch dimensional wood siding and it butts up to 2-inch or more, in some cases, if you're using 2-inch siding, you would have 2.5 or 3-inch by 3, 4, 5, 6-inch lumber, which is really the heavy lumber for the window trims. So it seems like that's inconsistent.
Yeah, I think overall, one thing to consider is that a lot of the contractors in this area will be subject to this code regardless if they're in the town or not. Anything within the WUHI, they'll have to start operating within this. And then very similar to like Mike said, there will be adopted codes in the future that contractors and other design professionals will have to adhere by. And that's where a lot more of the technical aspects will be outlined of how those assemblies are, per code allowed to be. I think overall the intent of this resiliency code is the fire resistance itself. So I think a lot of the more detailed stuff does need to be fleshed out. But overall, that will be for our building community and such. I think today with this session, we're really looking to kind of identify, are you even comfortable with going to complete fire resistance? Are you wanting to get rid of all natural materials? Like it's kind of what do you see as best, not picking away at the technical aspects of it.
I'm not sure how you can look at one without considering the other.
I don't know how many more of those points you've got in there, Mark, but I'm wondering if offline even we could, if you shared those with us, we could have a meeting
Meet
with
with you guys?
with the building staff
Yeah, sure.
and go through it all.
I would join that if it's okay.
I think that'd be a good idea.
Yeah.
Because I see a lot of
Mhm.
ambiguity. I think the intent here is very good.
Yeah.
I think the specificity is missing. And I think that the specificity is very necessary if we're gonna adopt something that's gonna have such a big impact on the buildings. And the problem really is when somebody needs to replace the siding, repair the siding, and they're suddenly thrust into what the new regulations are on their existing home that was built 5 years ago, 10 years ago, whatever. and now they've got to move up to that. And does that mean they have to replace all the siding on their house? And I think these are important things for us to take a look at because they have huge financial implications to the people that have to deal with it.
I thought it was just limited to 25% additional.
That's a
for-
trigger, yeah.
That was the trigger for it.
Once it exceeds the 25%. So take, there's roof damage or something, and they're taking apart a portion of your residence.
Falls on
As
the corner of the house.
if that exceeds 25%, you're expected to replace the entire roof material. In terms of like the 500 square foot addition, if it exceeds 500 square foot, that portion is only subject to these provisions. And then obviously any new construction would be subject to these provisions. So, I mean, some of this is, pretty fleshed out, and definitely, as you probably saw when you reviewed this, there are some additional, I guess, guidance for alternative materials, and kind of what you were speaking in earlier of just like the testing of materials within our climate. All of that's outlined within this code. Obviously, it's not specific to our exact region. It's for the entire state, which is a very large area encompassing of many different parameters. But this is kind of the minimum baseline. Staff, as mentioned, can basically take this base code and we can specifically apply it to the town of Breckenridge. So any concerns, like we do with our building code, we can adopt certain amendments to that code to make it more specific to our jurisdiction. But like I said, it has to meet the minimums that the state has identified and then it be approved for
Mark,
us.
let me read you one other thing and then I'll shut up about this. Under flashing, it has a minimum of 6 inches of metal flashing or non-combustible material applied vertically between the wall sheathing and the exterior cladding shall be installed at the ground, decking, and roof intersections. What does that mean? I certainly don't.
It's
know
just a
what that
fire
means.
break between a deck and a house or between an eave and the house. It's a fire break.
So, but they're talking about vertically, not horizontally.
Doesn't
So
matter.
where you have the two coming together, you have flashing that's horizontal, not vertical.
So
Does it say a vertical height? So even if it's horizontal, it's saying a minimum
I don't know.
height. That's, I guess,
So that's an example of how things need to be a little bit more specific, so we all understand what that means. I understand about a fire break, but to me, a fire break is flashing that goes horizontally, and it may go vertically, but they're saying vertical.
So the beauty of a performance code is it allows the experts to develop solutions that work, whether it's the designers or the builders or the town planners. And I don't think we want to get into a situation where we're providing construction details yet. That's more, as Chris said, something that is in the jurisdiction of the building department. This is big picture, upfront, top down.
But I do agree, the building division will be working on these, and honestly, it's probably gonna be a joint effort with Summit County and that everyone's, as Cliff was saying, everyone's in this together.
Okay, I have a few questions if you're done.
Oh, yeah, I'm done.
Okay. So it's only properties that have been judged to be historic that have qualified for historic status that would be exempt.
Yes, it would be any buildings within our local historic district that have been identified as contributing structures within the.
So
I wanted to clarify that's not exactly what it says. It says that's one of the parameters, but we can also say structures that meet our historic period of significance would also qualify. So there wouldn't have to be a contributing structure. It could be anything that we have locally designated as historic. Yeah.
right. Yeah.
Doesn't have to be in the historic district. It could be outside of it and historic. Too.
Based on the provisions, I believe so, but that's where the specific criteria, for us, it really identifies the nationally registered historic district and then any of those historic buildings within that. There's kind of specific criteria, and I think there's like 3 or 4 that would help certain structures, qualify for that historic structure exemption.
So, so it's possible that we could receive more applications for historic status or contributing status.
Are you saying like from historic properties that want to do structure hardening?
Yeah.
Yes, but kind of as we discussed earlier, like we would really want to find the balance of preserving that character, the historic materials, and then, what are the areas that we can implement structure hardening? So obviously, like the roof would be, a prime example, but then kind of to the earlier discussions, where can we still preserve historic material? If it's leaving it in the wall and then kind of wrapping the building in a non-combustible material, and then that would be meeting the intent in the code, but then still preserving the historic material. So it's just a matter of, does it still keep the character of our area?
Right. And Mark alluded to the fire retardant sprays, and I realized, that's hard to monitor, but would we want to encourage historic properties to try to use materials like that?
Yeah, I'm not sure that we've gone to that level of thinking about. I think we were initially concerned that would require the removal of historic fabric and altering of the building. I think since there is the carve out that exempts historic buildings, I think that then kind of the hierarchy of our code would generally be the handbook first, then this code, in terms of what's recommended or suggested, and similar to how the handbook is kind of over the development code or other codes in the town. But I think that we were just looking at it from like, well, we're not forcing anyone that has a historic building to alter their fabric
Right.
with this. And I think also from the mapping, we're, maybe relieved a little bit that really were the location of, I'd say almost entirety of our historic resources within the town limits is in that area. It's kind of the lowest risk as well. But that's not to say if there's other things that we could look at, best practices for hardening historic buildings, but I don't think we've gotten to that level of technical specificity.
Okay. And then I understand you saying that if you construct an addition to your house and it's 500 square feet or larger, then you have to use these fire resistant materials. But that's not going to apply to the main structure, right?
Correct.
Yeah, so we're going to have some compatibility issues, I assume.
It's definitely a consideration that we would want to look at.
Yeah.
I don't think that the architectural compatibility would be that much. Like there's plenty of examples where there's mixed materials between natural and non-natural, and I think to Mike's point, that's the job of the designer to
Right.
design an appropriately compatible building. Yeah. So I think that might be less of an issue versus, some of the other things you identified like cost and other things.
Right. Okay. And just one final small point. You referred to policy 47R, but I only found policy 47A.
48.
Huh?
48
Oh,
is our existing voluntary policy.
okay. Now I'm confused because the whole time we've been talking about 47R.
So there's 22R,
Right.
or 22A and then 48A. 22 is our landscaping policy that has the required
I understand that.
fire mitigation, and then 48 is the voluntary. I don't know if I
Yeah, but
misspoke.
But in question 5, you refer to 47R fences, gates, and gateway entrance monuments for the fencing.
Oh, okay. Sorry for fencing materials. Yeah, I'll have to look at that. I think it's
I only found
47.
47.
It may be A, so that's just a typo.
I-
Sorry
I-
about that.
I just wanted to make sure we were,
Thank you.
and I
Susan.
wasn't missing something. Okay, then we can move to comments, Alan,
All right, thank you, Susan.
and let's include our answers to
Answers,
the
sure.
questions.
So I have a concern about offering positive points. There could be a little bit of a conflict here. So someone could remove all their trees and get negative points, and they'll make up for it for positive points with hardening using hardened materials. So in a sense, they're getting the best of, they're already mitigating fire by removing the trees, and then they're making up for that. So I think we may have a lot of bare lots. And I think that I'm a little concerned about offering positive points for using it. It might be something like we have with the EV chargers right now. That'll be a makeup that people will use. I'd rather see maybe awarding points for a smaller footprint that keeps the home away from the combustible material.
So to clarify though, you can't clear your entire lot. There are minimum landscaping requirements under 22A. There's a threshold where you can clear to get negative points. So just a clarification, just to make sure that everyone doesn't think that we're the cut every tree down in the name of defensible space and you can take points. That's not how
But I think
policy 22A, I mean, and it's a value judgment, but I think one of the things when you're eliminating some of the low hanging fruit, because in order to have a performance based code, you need some calibration. You can't say we don't like anything enough to give it points, and we also think everything is valuable enough to give maximum negative points. If that's the philosophy, then we should have like everything should be an absolute policy. So we need to have, so we were, asked by the council, because that was one of the biggest things coming out of the work sessions on these topics was, okay, we hear you that, we don't need to incentivize landscaping and EV chargers like we did maybe a while ago. So look at some other emerging things that we want to incentivize now. And so kind of in the short list was building hardening, since there's a big push at the state level, really at the national level, coming out of some of the big fires. And I guess to have a house that doesn't burn down is not only a benefit to yourself, but it's also a benefit to your surrounding neighbors. So there is some broader, but
But
that's
my opinion is that I'd rather lean more towards absolute than relative, because if you really want it hardened, then say this is now a requirement. Because again, I think someone may just decide to do a design that has. I liked what was coming out of the work sessions I read when you had the contractors come in, is give points for less is more. So a smaller footprint, smaller home and such, and that's my opinion. So that's my comment. And again, I do agree that I think for the historic district, we need to reconsider as a commission some of the man-made materials that are more natural-like. I know a majority of the commission felt when we reviewed it with Sarah 2 years ago, we rejected most of them, but I think it's time we reconsider it. It's the same thing like solar is what's more important in a historic district, sustainability and have solar in the historic district, or not see solar. And I think in this case, what's more important, structural hardening or, original materials or non-man-made materials. So I would support another look at which fire resistant materials can we allow in the historic district? And in terms of the questions, I think staff recommendation that the town adopt code amendments, I agree. Number one. Number two, again, to some extent, I think maybe a relative policy for positive points, but I just, my concern is, as I said before, is that it becomes a way to get around doing some other things that we don't want, like site disturbance and a lot more removal of landscaping. Do we agree that we should get, yeah, I just said number three, yes, we should review and how we could use more fire resistant materials, particularly in the historic district. Again, I think four is just related to that. I think there's more we can do with in the historic district to meet this code and still preserve the character of the district. Five, yes, and we should definitely allow more flexibility fencing materials. I brought that up for the airport lot project. I think they should be considering, because there's other benefits of not using natural materials for fencing is, we have to paint them every 2 years, and where's that paint going? It's going into the soil. So we should, I think there's a double benefit there.
For the Blue River and eventually into the ocean.
Yeah.
54% of all the plastic in the ocean is from the erosion of latex paint.
Yeah. Wow.
But what about vinyl fencing?
What's that?
A leak into the ground.
Maybe not as much as paint, though.
Hey, Elaine.
All right, I'm just going to answer the questions. Number one is, should we adopt the CWRC? I feel very strongly that we should do anything we can to protect our community from fire issues. So yes, and I think that it's very well thought out. Sure, there's areas that probably need work. Number two, definitely like the idea of giving positive points for more fire resistant measures being done. I can talk about my house. My house has a wood shake siding, not on the roofs, but that's really flammable and it's hugely expensive to change that out. We looked at it and I don't know why we would need points for anything, but it'd be at least nice to be encouraged to do that by the community. Let's see, for 5R, definitely would like to see that revised and looked at. For exceptions for historical structures, it's already in the CWRC, so not really sure what we would change, but anyway. And then, sorry, I'm losing my voice. Fences, gates, and monuments. Not really fond of vinyl, but trying to be
metal.
metal, but you still paint metal, unless you're doing rusted metal. Or I don't really know what would not have paint on it that would be that. And then any additional comments? I'm just very pro changes to encourage this fire safety in our community.
Matt?
Like Elaine, I'm just going to answer the questions. I think all the other comments that I had thought of is kind of in the minutia or in the weeds and can be addressed by building officials or whoever else. Yes, the number one, I do agree with the the adoption of the CWRC code. 2 and 3 kind of go hand in hand, in my opinion, a little bit. Yes, you allow positive points, but carefully thought of positive points. And yeah, definitely eliminate the negative points structure for non-fire retardant materials. Yeah, definitely exemption for historic preservation. I think that it's one of those things where, like was mentioned, the bulk of the historic structures are in the town core, which are in that kind of zone 1 anyway. So I think that's an important consideration to make. Fences, sure. And then I also like to invite any building material discussion to maybe go through any environmental scrutiny by the sustainability team. Because I know some of that fire retardant materials or chemicals used to make fire retardant materials is pretty nasty stuff, and that gets in the water and the environment, and it's the hot topic right now. So I'd invite any sort of materials that become allowable due to this to be scrutinized by that team. That's all I have.
Thank you. We'll definitely refer this to our sustainability team and particularly Jesse Burley.
Ethan, comments?
No comments. 1, agree. 2, agree. 3, agree. 4, agree. 5, agree. No additional comments.
Thank you, Ethan.
He's in a hurry to go home. Oh, wait a minute.
Oh, no. I'm thinking about it, but you guys have all filled in the spaces, so I'm done.
Mike?
Agree. 2, could you clarify pathway? Do you mean like a fuse, like a fence that runs into a house, or do you mean a strategy?
Strategy.
Okay. Yes, I agree. 3, review to reduce negative points in existing, yes. 4, I feel quite strongly that we should not exempt the historic district, but that it should have its separate code requirements. I think we should look at the best practices in historic structure hardening, and the Park Service has great examples of that. But frankly, the low-hanging fruit on that is roofs, landscaping, the up to 5 feet, just as Cliff said, and then ventilation openings in the building. And if you cover those 3, you'll go a long ways to protecting the historic structures and the character of our town. So I think it would be tragic to lose an ex-urban subdivision, but it would be really tragic to lose the historic district. Fencing, yes. Additional comments. The Santa Rosa fire showed that the built-up areas, even the core of town, not just the wildland urban interface, the perimeter of town, are vulnerable. So another reason to pay attention to the conservation and historic districts. And then, as you well know, Mark, this will require a lot of community engagement in order to work. But thank you. This is a good effort, Cliff. Thanks.
Mark?
Number 1, I think that we should adopt the CWRC with the caveat that we clean up some of the ambiguity that I see in this code. I agree with number 2 and number 3. And I believe that I agree with number 4, and I'm very sensitive to the comments that Mike has just made about this in the historic district. And I agree with number 5. And with regards to the review of the non-combustible materials and the comment made by Mr. Smith, I think that we need to open ourselves up to a lot of new materials, and I have some of them right here that are coming out. The California wildfires, there's a tremendous business of selling good fire-resistant material. And this material right here is thermally modified wood. So when they take this up to just below the combustion point of wood, it actually modifies the cellular structure in such a way that it has properties that regular wood wouldn't. So with this kind of material, if you're in the historic district and you need to replicate the cornices with moldings and everything else, there are materials out there which we can find and which we can approve the use of, which will allow people to do that without compromising the architectural integrity of the building.
Thanks. Okay, I agree with question 1. I agree with question 2. I agree with the building material issue, the exemption for historic preservation, and review of our policy on fencing materials. And I appreciate the comments that others have made regarding the environmental impact of some of these hardened materials and things that we should be considering in hardening historic structures. Thank you very much. I think we can move to the town council summary.
Thanks. Good discussion, guys. And I just want to recognize Cliff. He's done yeoman's work on this whole, keeping on top of this. As Chris said, the responses he's provided to the state that helped them provide that little carve out for historic properties, although we'll certainly consider Mike's comments on that too, in terms of not just ignoring them. But Cliff's just done a great job on this, pulling it all together, and it's obviously a lot of information. So, yeah, so council met on July 22nd, a couple weeks ago, and just got a couple things to report on. They did discuss the runway project, several things regarding that on Block 11, the new housing project, and really we're getting into the details on the deed restriction that they want to put in place. So there wasn't total conclusion on everything, but one of the things that they kind of want to push on the project itself is building out a certain amount of ADUs, accessory dwelling units. So there's going to be roughly 44 units in the entire project if they decide to go forward with it all. They haven't decided to move forward with any of the vertical construction yet. They're getting close to making a decision on the first half, the first phase. But about 44 of the single family units will have basically a shell second story above a garage that could be converted into accessory dwelling unit, much like the carriage houses in the Wellington. And so council is thinking about some percentage of those would actually be built out, which would raise the price associated with them, but it would provide the opportunity for people that did buy that product to recoup some rental income and possibly make their overall mortgage more affordable. So anyway, that's one of the discussion points they had, and they're going to continue to have as they move along here. Another thing, just a general update on revenues this year in the town. You may have heard lodging's down in like 10 to 15% for the year. Revenues are fairly flat compared to what was projected by our finance department for the year. They were fairly conservative. You can't just keep increasing every year in sales taxes. It's not very sustainable. The revenues are slightly down from last year. So it's something that the council has definitely taken a close look at just to, manage that. And there's discussions with the tourism office about, do we open up more marketing to the front rangers, which in the last few years, it's really been, we're not doing hardly any marketing to the front rangers other than maybe Oktoberfest. And that's always kind of been one of the festivals, that they've come to and that they've marketed for. But it's really been about reaching out to those out of state, and visitors that are coming in for longer periods of time. So anyway, that's all kind of in play right now. As there just some uncertainties about where, the economy's going from here. But anyway, the other thing that was a discussion point was neighborhood preservation, and I'll let Chris give you an update on that.
Yeah, so we finally circled back to the council with neighborhood preservation. As you recall, we had a work session in it was either late February or late April or early May on the topic. And we had some preliminary suggestions by the council, and basically have run that through, a specialized working group of builders and design professionals, the planning commission, and then opened it up to 2 public open houses. The second of which was fairly well attended, and then Sarah was there to assist me with that one. And through the feedback we got throughout the process, it basically had a very modest level of support for the council's recommendations. I think there was a general, the majority of respondents, there was some concern about where things were headed in terms of some of the homes that were being constructed in these older, large lot, single family neighborhoods. But yet there was also a lot of apprehension to implement any additional regulations on there. That was kind of there's a lot of people that could point to one structure they didn't like, but they also are like, I don't really want to impose any, I think they have a pretty good understanding of that we do have a fairly rigorous design review in the town, and they were pretty apprehensive about saying, well, it's layer on a bunch of new policy. So with that, we made the recommendation to address eliminating positive points for EV chargers and for landscaping on single family lots, and then eliminating the relative setbacks, and basically taking the relative setbacks and making them absolute for single family homes that do not have a building or disturbance envelope. And that would be in phase 1. Phase 2 would be looking at kind of roof design, building height regulations, such as a bulk plane for various neighborhoods. And then also looking for possibly new positive points, kind of on the lower end of the spectrum, building hardening being one of those that was mentioned. So pretty quickly, we're to go the first reading on August 26th for the first phase of the NPP code amendments, and then I'll be looking to formulate kind of a small working group to look at bulk plane and building height, which I'm looking over at a certain individual over there that probably this week I'll be getting in contact with. I think I'm going to ask Mike to be the representative for the planning commission. Just because I know he has a really good working knowledge of bulk plane in his own neighborhood, and it was also suggested during the planning commission work session. And then we'll get some other designers on board and hopefully get to work on that and see what we can come up with to go back to the council for another work session.
Maybe just one clarification. The council seems still to want to offer possibly 1 point for EVs. They didn't want to necessarily get rid of them altogether, but then there was a thought of, and maybe that's for 2 chargers, not 1. So anyway, they're definitely reducing that incentive significantly, but still leaving it a little bit on the table.
Yeah, that's correct, Mark. Thank you. Yeah, once we proposed the full elimination, I think they thought, well, maybe we can cap it at 1 and get a couple more out of it.
Did they get a call from Elon Musk?
Can't do that.
That's it.
Thank you, guys. Thank you, Cliff. Nice work.
I got a question regarding permits. We reviewed a project down by, the building center for New West Partners.
Mhm.
And,
Food market? The food market?
Market?
yeah, the market.
Yeah.
right. And I believe that, I don't know where that went after we did it, whether they went in for permit. I think once you get a building permit, you have 180 days.
Yeah, they never got their building permit. Their development permit was vested for 3 years and it expired,
Okay.
a few months ago.
For sale.
So, yeah.
Said, that was my next question, because I noticed a lot was for sale. So whoever buys that's got to start all over again.
But Highland Shores is advertising to buyers that there's gonna be a market there.
Really? Highlands Riverfront. Yeah, yeah.
They're telling everyone you're gonna be able to, you're gonna be 2 blocks away from a market.
Be not.
Okay. It is 7:45 and the meeting of August 5th is concluded. Thank you.
Bye, guys.
I think
Thanks. Bye.
Ethan?
Good job.